You're listening to Lawsuit Proofing Your City, a podcast with Scott Grossberg. Each week, we explore current trends in lawsuits brought against cities and give you tips, tricks, and techniques for fighting back. And now, here's your host, Scott Grossberg.
Welcome, everybody. I'm excited to share today's episode with you, and we're going to begin with a question. If an incident happens at or in your agency, and I ask you for all documents that relate, refer, and pertain to that incident or to that location, where would you go to get all of the items that I want? And how can you be sure you've collected all of them? And once you collect all of them, do you know what to do to preserve them? Predatory lawyers know that this is a weak spot for you because in many cases, I find that clients don't know what they've collected, they don't know where to go and look for it, and they don't know how to preserve all the evidence. Unfortunately, predatory lawyers are now using the California Public Records Act to conduct pre-claim and pre-litigation discovery against you. Let me say this a different way. Before the claim is filed, before a complaint is filed, plaintiff's lawyers are serving you with a California Public Records Act in order to conduct some preliminary investigation and, frankly, put their case in order before they ever serve a tort claim. In my opinion, the concept behind the California Public Records Act has now been perverted. Originally, the Public Records Act was designed to give people access to information concerning the way you conduct business. But now we're seeing predatory lawyers use the Public Records Act to further a claim and a lawsuit. They're also serving you, by the way, with litigation hold letters. You may, in fact, have seen an increase in these types of letters. These letters claim that there's a duty on your part to preserve evidence. And here's a tip for you. Here are some quick triggers for when you should internally determine that evidence needs to be found. First, if there's a major incident. Second, if you're served with a claim. Third, if you in fact receive a Public Records Act request. Fourth, when you receive one of those nasty litigation hold letters. And then finally, if a lawsuit is served. I'm even seeing predatory lawyers, by the way, using journalists, using the media to do their work for them. They'll give a journalist a call, claim that there's a breaking story, and then hint to the journalist that they should contact you to uncover information. This may indeed spark the reporter to use a Public Records Act request to gather information, and of course, then the predatory lawyers piggyback on the journalist's activities. If the other side is really unscrupulous, I've had them call law enforcement or the district attorney's office, and they will then do whatever it takes to get an investigation opened, and then subsequently will seek a production of records that have been obtained, collected, and maintained by either the investigating law enforcement agency or the district attorney's office, and at the very least they're going to ask you for copies of all the documents that you've turned over. What we really want to address today is bringing your attention to the potential that you may have inconsistent document retention policies. And there are two different types of documents that you might have. You might have digital, and you might have what I call terrestrial documents. Those are paper documents. You might also have inconsistent document storage locations. You might have inconsistent document retrieval techniques. And of course, you might have inconsistent format policies. To put it another way, there are documents that get stored in their native format, and you've got to then wonder how do you produce those to a Public Records Act request. And there are other digital files that frankly are what I call dynamic and recyclable. They're constantly changing and shifting as people are working on them and have access to them. Again, all of this document retention discussion becomes compounded by the preservation of evidence demands being made by plaintiff's counsel. Here's the kind of thing you're going to receive in a letter. They're going to request that all documents or other data compilations which might impact on the subject matter of the claim or the lawsuit be preserved, and that you eliminate any ongoing process of document destruction involving those documents. They're also going to ask you that in the event you have destroyed documents, you are then requested to describe in detail the circumstances and the reasons for the destruction. To make matters worse, I've had some employees tell me that they've gone to training, certainly not mine, where they have been told that a document is no longer a public record if they take the document out of a file cabinet or a file folder and put it in their own personal briefcase. And that's just not true. We also find this situation compounded when staff doesn't really understand what they're looking for, or worse, they have apathy about what they're looking for, which then leads to them not preserving the evidence. And finally, we've got elected officials that don't understand how all of this applies to them. There are some solutions here. I'm going to give you one big tip. If I come to you and I ask you for documents that relate, pertain, and refer to something, one of the first places you should look is the finance department. Why is that? Well, think about it for a minute. Finance tracks where all the money is spent. They track outside vendors. They track descriptions. And most of my agencies forget to check with finance. And finance usually has documents that will help me expand my personal investigation and could potentially lead to us making an indemnification or tender of defense to an outside contractor. Naturally, one of the solutions is to go to the department itself that's involved in the incident or the claim or the lawsuit, and that implies that the department has documents that are searchable. That means when you're done listening to this podcast episode, you go back to your IT personnel and ask, what exactly are we doing for a policy to ensure that the documents we've collected and assembled and maintained are searchable? There are outside companies, by the way, who specialize in everything I've just talked about. They will come in and do an audit for you and help you to establish best practices for storing, maintaining, and being able to retrieve these critical documents. The beauty of bringing in an outside company or consultant, by the way, is that they are impartial and can assist you in implementing and monitoring any litigation holds that are put in place. The biggest key for you, the biggest takeaway, plan ahead for the locating and production of relevant documents. And again, make sure you go to the finance department if you're asked for the production of documents. Well, that's it for today. Thank you for joining me, and until next week, as always, here's to us taking back the courtroom together.
You've reached the end of another episode of Lawsuit Proofing Your City with Scott Grossberg. If you like our show, we'd love for you to subscribe, rate our broadcast, and leave a review. You can always check out lawsuitproofyourcity.com for more information and show notes. And remember to go to the archive section on our website for previous podcasts. This podcast is for general information only and not intended to be legal advice nor the formation of a lawyer-client relationship. Stay tuned for our next episode, and thank you for listening.